Hey guys, welcome back. I got an update from the George Floyd story for you guys. Can you believe it? Derek Chauvin is actually asking to have the courts to toss away his convictions. Stay tuned, I'm going to bring it to you guys. But first, you know what I need. I want you guys to hit that subscribe button, hit that like button if you like the video, smash on that notification bell so you be aware when the updates coming out. And always leave me a comment in the comment section. I love to hear from you guys. Thanks now. This video is being made for educational, informational, and entertainment purposes only under the Fair Use Act. No copyright infringement is intended. Okay, guys, I guess this is just routine for the courts, but believe it or not, Derek Chauvin, the police officer who crossed over George Floyd in Minnesota, has actually appealed his sentence and is asking the court to toss out his conviction. Now, first thing, I guess I just need to go on and throw my opinion out there. What makes you think that you're entitled to that? You were seen on national TV all throughout the whole entire world with your knee on the man's neck while people were standing around telling you that you were about to cross this man over and you didn't care. You were arrogant and you didn't care. So why do you feel like you've been treated unfairly? And like I say, I guess it's just routine for the courts to ask for appeals. But why would you feel like you've been treated unfairly? What about that man's right who was under your knee? In an article from WUNC, North Carolina Public Radio, the article states that Derek Chauvin's lawyer has asked Minnesota appeals court to toss his conviction. I don't want to say the M word, you guys. As a matter of fact, he's asking them to toss his convictions with an S because he was convicted of several things. Now, the article goes on to say, a lawyer for former Minneapolis police officer Derek Chauvin made his case on Wednesday for why his client's 3 convictions in the crossing over of George Floyd should be overturned, which the state vehemently rebutted, thank goodness, as they should and as I knew they would. Speaking before a 3-member panel on the Minnesota Court of Appeals, lawyer William Morman argued that extensive pretrial publicity made it impossible for Chauvin to get a fair trial in 2021 and said the main remedy they are seeking is a new one. Okay, the pre-trial publicity was the publicity showing this man, George Floyd, underneath the knee of Derek Chauvin, saying that he was unable to breathe and showing his ultimate crossing over right there on live TV. Okay, so the pre-trial publicity was from what he did, not the things that were said, because yes, there were things said, yes, there was a lot in the news media, yes, there was a lot of things that was seen and done before the trial, but the bottom line is that everybody in the nation and maybe in the world saw what happened and saw the results of him having his knee on this man's neck, and his arrogance basically letting the world know that he really didn't give a hoot what anybody thought. The arrogance that he sat there with this knee on this man's neck while the people standing around and the passerbyers were saying you're going to do things, people there that could have helped him, that was willing to help him. His arrogance, and this is just my opinion, guys, his arrogance is what eventually led to the crossing over of George Floyd. And I don't understand what it is that he wants. Now, yes, the courts are going to follow protocol. They are going to ask for appeals, and they are going to try to get the convictions thrown out. That's the way the law works. That's the right of every human being. I'm not taking it away from Derek Chauvin either. But because of pre-trial publicity, the pre-trial publicity was what he portrayed. Okay, the article goes on and reads, our primary argument here is that this case could not be tried in Minneapolis because of the pre-trial publicity, which was pervasive, and also just the physical pressure on the courthouse, Mormon said. Former acting U.S. Solicitor General Neil Katyal, representing the state of Minnesota, countered the defense claims by calling Chauvin's trial one of the most transparent and thorough in our nation's history. I agree. He said that many of the arguments before the appeals court do not come close to justifying a reversal, and that even if they did, the evidence of Chauvin's guilt was captured on video for the world to see. My sentiments exactly. The article goes on to read, each side had 15 minutes to make an opening statement and respond to questions from the judges, after which Mormon had about 5 minutes to give a rebuttal. The panel said it would issue an option within 90 days, meaning we can expect a decision by mid-April. It really shouldn't take that long, guys, because like they just said, it was on video. So you have 90 days. I guess you use your entire exhaust your 90 days, but the verdict should come back the same. And we remember how this crossing over sparked protests throughout the world. Many people came together and marched, of all nationalities, all races, all creeds, all colors. Everybody saw with their own eyes what happened to this man. And it sparked so much protest and so much anger that anybody who knows the story can definitely understand. Now back to the article. Chauvin would spend decades in prison either way. Floyd, who was black, died during an attempted arrest on May 25, 2020, after Chauvin, who is white, pinned him to the ground with his knee on his neck for more than 9 minutes. His death was captured in widely circulated bystander video and sparked protests against racism and police brutality across the U.S. and around the world. And this is the article that just said what I said prior. The following June, after jurors found Chauvin guilty of second-degree crossing over, third-degree crossing over, and second-degree manslaughter, Hennepin County Judge Peter Cahill sentenced Chauvin to 22.5 years in a state prison. I need to put my opinion here again. I don't feel like that was enough. A federal judge later sentenced Chauvin to 21 years in prison for violating Floyd's civil rights. Chauvin is serving both sentences concurrently in a federal prison in Arizona. He waived his right to appeal under the federal plea deal, which is why he is pursuing it in state court only. Because of the differences in parole eligibility between the Minnesota prison system and the federal system, he is poised to spend nearly 3 more years behind bars than he would have with only the state crossing over conviction, the Associated Press explains. In other words, if Chauvin were to win an appeal in state court, he would still serve a considerable amount of time in a federal prison. Still, the AP notes a successful appeal could set a precedent for future cases involving police officers. And that's one to think of, guys, because with the way things are going these days and the way that they go out of their way to protect these officers, with the qualified immunity and with the different things that they do to cover for them and to protect them, I'm not going to say I would be surprised if he walked away from this, but it really would be something to think about. If he were to have this tossed out, it would only empower the people, the police officers, to be able to freely do more than what they are already doing, and we already are in a crisis in the United States with brutality. The article goes on to read again, the appeal has been in the works for a while. Chauvin formally announced his intention to appeal his conviction and sentence in September 2021, and his lawyers officially filed the request last April. They were asking the Minnesota Court of Appeals to either throw out his conviction and send his case back to the county, reverse the result, and order a new trial in another venue, or order Chauvin a reduced sentence. Because to me it seems like they just want to get him off for this. The article also says, they say issues with the trial include the considerable pre-trial publicity, the city's $27 million settlement with Floyd's family, which was announced during the jury selection process, unrest over a separate police crossing over in a Minnesota suburb during that time, and unprecedented courthouse security. They are also alleging prosecutorial misconduct, handling of witnesses, and the judge's exclusion of evidence that could have been favorable to Chauvin. Chauvin's defense team has long argued that the trial should have been held somewhere else. Prosecutors have in turn stated that Chauvin did receive a fair trial and a just sentence, contending that a charge of change of venue wouldn't have made a difference, and noting that the judge took steps to ensure the selection of an impartial juror and shield them from outside. The hearing focused mostly on venue and jury issues. Wednesday's hearing offered both sides an opportunity to highlight key pieces of their arguments and answer judges' questions in real time. Some of the issues that came up involved allegations of cumulative testimony by the prosecution, the nuances of presumptive prejudice, and the permissibility of the third-degree murder conviction. Most of the back and forth centered on one juror referred to as Juror 52. Chauvin's team is again pushing for what's known as the Swartz hearing to probe alleged biases, because they say the jury didn't honestly answer a question on the jury selection questionnaire about whether he had attended any protest against police brutality after Floyd's crossover. The jury did not mention his participation in a Washington, D.C. march honoring Martin Luther King, Jr., in which Floyd's death was mentioned, but not the central focus. Mormon said if he had answered otherwise, counsel would have asked more questions before deciding to seat him. One judge on the panel took issue with that, saying the questionnaire used the word protest rather than rally, and that even the defense's brief seemed to acknowledge that the difference because it did not use those words synonymously. He added, and Cattell also argued later, that Juror 52 was truthful in all of his other answers, including his views on discrimination in the Minneapolis Police Department, Black Lives Matter, law enforcement in general, and his ability to render an impartial verdict. It's not as if Juror 52 was some closeted Trojan horse trying to hide his views. He was as forthright as possible time and again, Cattell added, adding that the standard required proving that he necessarily lied, while in his view the evidence showed at most an honest mistake. Mormon said a Swartz hearing will not be necessary if the court decides to send the case back to the district court, either to hold a new hearing or choose another venue for one. The venue was another topic discussed at relative length. Mormon stated that the trial should have been held somewhere else in the state, citing jurors' self-expressed concern for their safety and the fact that the governor had deployed the National Guard throughout the city days in advance of the verdict out of concerns about riots of Chauvin's acquittal. He said jurors had a personal stake in the outcome of the case because they lived in the community where the riots occurred and believe it would have been a different situation if the trial were held outside of Minneapolis. Cattell disagreed, saying that if pretrial publicity is going to blanket the state, then there is no advantage to shifting the venue. He added that Cahill had already said on the record that having the trial in Hennepin County would be safer and actually make the jury more impartial, because there were still fears of civil unrest outside the city and security precautions would actually stand out more. The panel pushed back and asked questions of both parties throughout. And while their ruling could be months away, they stressed repeatedly that theirs is an error-correcting court that defers to the district's court discretion, which they said is very broad in many of the areas up for discussion. So guys, in April or somewhere between now and April, we should be hearing the results of this, and we're going to stay tuned, and I'm going to keep you guys updated. So next episode of the results of this is to come, and I'll be bringing it to you guys, freshly squeezed juice. Thank you guys for coming. You know I got much love for you, and what I need you to do for me is that if you didn't get the opportunity to like and subscribe to the channel in the beginning, this is a second chance for you. I always try to do a second chance. So go on and hit that subscribe button for me. If you like the video, hit that like button. Smash on that notification bell so you can get the updates as they come out. And I'm going to be on this between now and April, so you want the updates. Smash on that notification bell. And always leave me a comment in the comment section. I'm always want to hear what you guys got to say. Much love to you. Smooches, baby. Smooches.